The criminal libel and seditious law was repealed in 2001. That law sought to criminalize speech. It would seem that the repeal of that law would have done away with the criminalization of speech. Recently, the Fonka Director of Operations, Ernest Owusu Bempa, was picked up and detained for alleging that the First Lady, Ernestina Nadu Mills, had received a $5 million cash gift from the NDC financier Alfred Woyomi. Bempa was charged with publishing false information likely to cause fear and panic. There's a case of Amina in which she alleged to have been aboard a bus traveling from Accra to Tamale, the northern region of Ghana, where the bus was waylaid by armed robbers who forced the passengers to have sex with one another. She's being prosecuted for publishing false information with the intent of causing fear and panic. There's also Atoko Amina Dazi, formerly of Joy FM, who was charged similarly. The focus today is on the manner of arrest and charge and sometimes prosecution of persons under the Criminal Offences Act of what is clearly a civil matter, publishing false matters about another person. What does the law on publishing false information with intent to cause fear and panic say? Should publishing something libelous about a public official warrant the involvement of state machinery? And did the police have the right? Did they have the act? Did they have the right to have acted on behalf of the First Lady? Did the police have that right? And what was the justification in picking Owusu Bempa up? How can we deal with this as a country? So dealing with libel this evening, I have introduced my guest to you already. My first question to you is to Commanding Officer Hamza Yakubu. The law mandates the police to keep public peace, right?
Sure.
You have the right to arrest.
Sure.
Is the law specific on how these arrests are to be made?
Yes, certainly we are clothed with the powers of arrest. And the purpose of arrest is to get the person to come to answer for alleged offenses committed. Mm-hmm. And we cannot just do it out of nothing. We strictly have to do it, bearing in mind the fact that everybody has a constitutional right to existence and whatever. But then, in arresting, we must make sure that our action is within the powers and authority that we are clothed with. And then again, our action ought to be justified. Then it must be, like I said earlier, within the constitutional rights of a citizen.
What are the constitutional rights of a citizen if we were to look at it under the context of police arrest?
Under the context of arrest, what we ought to do is, like I enumerated earlier, that the action ought to be justified and that the person ought to be given a treatment that deserves, that a human being deserves. In arresting the person, the fact that the person has committed an offense does not mean that you can mistreat the person or anything. You've got to accord the person the treatment.
Okay, assuming I have offended the state,
yes,
or one way or other, and you're coming to arrest me. I'm in my house. You knock on the door, I open it for you, and then what happens?
The circumstances, normally, generally, it is expected that arrests are made with warrants. But then we all know the difficulties in getting at these things. And there are certain instances you will certainly not need to be chasing a warrant before you effect the arrest. So you are told, I come, I extend an invitation to you. And we expect normally that having extended an invitation, you should honor it.
And so I follow you?
Sure.
Are you going to handcuff me?
No, it depends. It depends upon the nature of. For instance, if we are told you are an armed robber, or you've committed a very grievous offense, rape, causing harm, and we come, certainly we are going to have you handcuffed immediately we chance upon you.
Because I might want to escape, is that it?
Not even escaping, we also have to take precautions to make sure you do not cause injury to yourself or injury to the arresting officers.
I see. So when it comes to detention of persons, do we consider what the law says? How long can you keep me in custody, for example, after having arrested me?
48 hours constitutionally. Within 48 hours, we should be able to put you before a court or release you on bail.
And within the 48 hours, what's supposed to happen?
You are under investigations. So you are supposed to be treated fairly, given all the opportunities that the laws of the country allow.
Interesting. You're not supposed to keep people beyond 48 hours.
Yes.
Yet repetitively, we've had incidents in this country where people have been arrested and have been kept beyond 48 hours. And there are specific examples. I could name them.
Come again.
There have been specific cases.
You said specific example.
Yes.
You were
For example,
yes.
you kept Osu Bempa in the cells for more than 48 hours. Right?
I cannot confirm or deny that, but I believe that we operated within the limits of the law.
And that you didn't go beyond 48 hours?
I'm sure.
That's interesting. Have there ever been a case where the police has kept anybody for more than 48 hours?
To be honest, I think yes. That is a fact. Sometimes it's an issue that has to do with issues beyond our control. The person might have committed a very grievous offense, a felonious offense, and it's not immediately possible to be able to put the person before the court.
Why? The courts will not be working within 48 hours?
Come again.
Will the courts not be working within 48 hours?
Sometimes the courts are not working, will not be available at that time.
Interesting. See, my mind is going to a situation where you would arrest somebody, say, on a Friday evening, and by Sunday they should have been, processed. 48 hours will be Sunday. So when it gets to Monday morning, do they have the right to say that?
I think we would. I believe that fortunately having learned people here, I believe that in that circumstances, these are circumstances that are beyond our control. And normally, it's also, like I said earlier, dependent upon the grievous nature of the offense, that we may have to look at the circumstances and then try to get the person properly before a court of competent jurisdiction.
Okay. Again, I ask you, why does it seem like the police have difficulty in divulging information when citizens are being denied somewhat, detained unnecessarily?
We don't have to just give information when it is that a matter is under investigation. Investigations are expected or supposed to be conducted in such a manner that would let you get to the bottom of the case. So once you are investigating, the essence of it is to come out with issues of evidential value. So you don't just go throwing out the little information that you have about.
With regards to detention, somebody has been arrested, they've been detained, and we want to know which police station have they been taken to?
It is always known.
Mouth shut.
It is always known.
How long are they going to be there for? What are they for? Mouth shut.
No, we don't need to tell you how long the person is going to be there. That is neither here nor there. You would certainly get to know the police station where the person is taken to, and we don't need to explain why that person ought to be at this particular police station, because so many things are taken into consideration. For instance, we look at the security of the place. If we think that the security of the place is not that which is enough to protect the arrested person or the person being investigated, we would relocate for the safe custody, for the purposes of safe custody of the person.
Thank you very much. Mr. Atakessin, you were a bit antsy when I was going through the process with her. Now, I asked a question. 48 hours. One is not supposed to be detained longer than 48 hours, yet it's been known to happen repetitively in this country. This person has been retained for 48 hours, or that person has been retained for 48 hours. Where does the law come in here? What right does the person have, or how can they protest even?
Thank you very much. Let me quickly make small correction here. The law we're talking about is with respect to Article 14 of the Constitution. It basically says that you have 48 hours to produce the person before a court of competent jurisdiction.
Okay.
So the impression is not that you cannot keep beyond 48 hours. If the police arrests, they have 48 to produce the arrested person before court. Now, the court may decide to grant the person bail or may remand the person in custody, in which case the detention will go beyond 48 hours. Okay. There are issues of institutional dysfunction here. In the context of even the question you asked, Chief, basically, if you arrest the person on a Friday, they have 48. Courts are not sitting on Saturdays, okay? So technically, you may not be able to blame them for not producing you before the court on
Sunday.
Yeah,
Sunday.
Exactly. So one way to go about this problem, in my view, might be maybe asking the court to sit on Saturdays and Sundays for cases like this, in which case the police will have no excuse for detaining you over, the weekend. I think these are issues that...
And these are issues that repeat because they say that was a weekend. And I remember there has been, and that was not in relation to libel, but there's been, during the elections, the 2008 elections, there was the issue of the court not working on weekend, therefore certain actions could not be taken, remember? So that's an interesting one. Now we're looking at libel. Let's go to what freedom of speech is, and then we can come to libel. What is freedom of speech? Where does one's freedom ends when it comes to one's right to express themselves?
Thank you very much. Again, my reference point will be the Constitution. If we look at the provisions of the Constitution, we have a whole chapter devoted to fundamental human rights and freedoms. And here we have Article 21 spelling out general, freedoms. Freedom of speech is stated in the freedom to receive information is in there. There are several other freedoms, okay? And for the media or the journalists, this provision is very key because the journalist or the media practitioner is somebody who is operating on the market of ideas in terms of trading ideas and getting the public informed. So these are freedoms which are equally guaranteed if you go further to look at Article 162 and as well as Article 164. So the idea here is that we are operating a democratic governance, or we are in a democratic society. And these freedoms of sharing ideas, trading ideas on the idea markets are good for pushing further, the noble ideals of democracy. Now, the media practitioner here helps in testing sometimes otherwise accepted conventions and norms, okay? The media practitioner at times, introduces controversy for purposes of really challenging us in the way we think. And of course, they also bring or they set the national agenda for debate, okay? And this is why all these freedoms are there. But of course, they are not absolute in a way.
Okay. When can one's freedom or right of expression be said to have become libelous?
I don't get the question.
When can one's right to express oneself, to be able to speak freely of any subject, of any person, can't be said to be libelous?
When it tends to impinge on someone's reputation unfairly or adversely, then your freedom of expression ends. There are so many things I can say about you as we're sitting here, but then if I go beyond a certain point and start touching on your reputation, on your person, in a negative fashion, in order to push you out there to the public as a person who is contemptible, or trying to ridicule you, or put you out there as a person who should not be dealt with by right-thinking members of the society, then I'm toying really with danger.
Would you be justified or unjustified?
It depends. It depends.
Because there are times when you might say
things. If the
things.
matter generally under the scheme of affairs, as far as our law is concerned, if the matter is true or is fair comments based on public interest, then it becomes justifiable. But beyond these general considerations, if, for instance, let me use myself as an example. If I said something and it was untrue, and you tell me that what you said was untrue, and I'm still insisting, you tell me that I'm a liar. Well, in court, if you're able to prove that what I said was untruth, then that is the truth, and that is your defense. So how have I impinged on your reputation if what you really said was untrue?
Therefore, libel can only be proven in court.
Well, It's like every legal
Because
construct.
I can make a statement against you, and if you find that statement to be untrue, and you want to prove that it's untrue, or I want to prove that it's true, that it can only be determined in the court of law.
That's what I'm saying. It's like every legal construct. We cannot, as long as we are not a court of law, we cannot sit and determine the rights and liabilities of others. We may think we have a case, and that is why the law comes in. There's always two issues. Sorry. Yeah,
can I get a yes or no to this answer? It's not possible.
You can't answer yes or no on a matter of law.
And I ask you this again. Issues of libel can only be proven in the court of law?
Like every legal construct, like if you are charged for a crime, it can only be proven in the court of law. If I sue you for some other thing, maybe you bought a car from me and you didn't pay back, I have to prove it in the court of law. So it's like every legal construct.
Interesting. Very interesting.
That is to say, you cannot sit in your house and determine that someone has libeled you.
Right.
There's a court that will have to determine that.
Right.
Like,
what is the police coming? If I say something offensive, that you find offensive, that you find that I have, defamed you, I have mangled your character, that, even if I think it's in the interest of the public.
Fortunately,
can the police make an arrest?
Fortunately,
and I go and report to the police that, hey, this person has said XYZ to me, and I'm offended, and I think that he's, actually damaged my reputation, and it's unjustifiable, so go and arrest him.
Before 2001, the police could do that. But in 2001, with the advent of the passage of the law that decriminalized criminal libel, then now the police cannot act as far as libelous acts are concerned. It also includes slanderous acts. See, formally...
What are the distinctions?
See, formally under our Criminal Offences Act 1960, Act 29, there was the regime under which you could be held for criminally libeling a person. It didn't need to be a state official. You could be held liable as long as you intend to bring him into ridicule, hatred, or contempt. If it is established against you beyond the reasonable doubt that is what you intended to do, then the police could come in. It becomes a criminal matter. But now, because it has been decriminalized since 2001, your recourse only now is the civil court. Formally, you could go both ways. You could go to the civil court, and the state machinery could also take the person on in the criminal court.
Okay, so let's take a look at Owusu Bempah's case. I mean, that's the case study for this evening. Did the police have the right to arrest him? And we know what he did. He alleged that the First Lady had taken a certain amount of money from, Woyeme.
Yeah, I mean, touching on arrest, let me say this. If you look at our Criminal Offences Procedure Act, the police indeed have the power to arrest even without a warrant. If they have reason to believe that one has committed an offense or is about to commit an offense or is actually committing an offense. I mean, let's get that distinction, okay? Now, this is a discretion that in a penal, statute we have conferred on the police, which makes the police very powerful here. Now, what is happening here is this, that, and in my study for purposes of this, I observed that there are several, offenses which are available, to the police. And that they may not necessarily need to even charge you for libel because libel is no more. And I think in this case, that's what they've done. They actually did not prefer the charge of criminal libel. So the issue does not even come in. It's rather the issue of publishing of false, news, which is an offense which is still there. Okay, it's still an offense which is there. Now, matters of criminal law are not at the mercy of the individual person. It's at the prerogative of the state. So the state may decide to prosecute or not to prosecute. Let's get it right. Okay, and for which reason, honestly...
The state?
Yes.
How does the state come in when this offense was done to an individual?
Well, you obviously have victims of crime who may be, may have their rights ventilated either in the civil way or in the criminal way, okay? Merely because the matter is being prosecuted doesn't mean you cannot initiate a civil action. There are two sides, okay?
Let me ask you this. Publishing false information with intent of causing fear and panic. In the First Lady...
Fear and alarm.
Well, fear now.
Fear and alarm.
Now is the specific case is fear and alarm.
No, the offense itself.
Is fear and alarm.
Fear and alarm.
So where from this fear and panic?
See,
that we have consistently, you know, put out there.
Let me take on from where
we've all become familiar with
my learned brother stopped. You see, sometimes civil matters may also have criminal aspects to them. For instance, if you take my car with the intention of not returning it to me, I could sue you the thought of conversion. The state machinery could also charge you for stealing. So
yes.
it is both civil and then criminal. But this is where the confusion lies. In the case of the gentleman, I didn't hear what he said, but from reports, and also from reports that he's been charged under Section 208, we should get something clear.
Is that justifiable? Was that a justifiable charge?
That's what I'm coming to. The offense itself is really not causing fear and alarm. The offense is publication of false news under Section 208. And with your indulgence, if you allow me to read.
Please.
Section 208(1). A person who publishes or reproduces a statement, rumor, or report which is likely to cause fear and alarm to the public or to disturb the public peace, knowing or having reason to believe that that statement, rumor, or report is false, commits a misdemeanor.
Can you run that by us again?
I could explain. I could explain. You see, you're looking for, in law, we always say that you're looking for an act and a prohibited state of mind before you can find a person guilty of a crime. Here, the law prescribes what the act has to be and what his state of mind has to be. Let's begin with his state of mind first. Knowing or having reason to believe that the statement, rumor, or report is false. So it is knowledge. He must have the knowledge that the statement he's publishing or the rumor he's mongering out there is false. That is the state of mind. But then the law goes on to tell us what will amount to knowledge. Let me leave that and come to the act, which is really the focus here. Person who publishes or reproduces a statement, rumor, or report which is likely to cause fear and alarm to the public or to disturb the public peace.
Right.
That is the act. There are two prongs here. First is you are either publishing the statement, rumor, or report which is likely to cause fear and alarm to the public, or second, to disturb the public peace. Okay. Now, let's ask ourselves, what does this mean and where does this gentleman's case lie?
Absolutely.
Okay. See, when the law talks about an act which is likely to cause an event, the law is dealing with reasonable probabilities. The law is not dealing with fanciful possibilities.
Thank you.
As we are sitting here now, it is possible, and you cannot fault me to say that it is possible that I can grow wings, right? And I always tell my students, and fly out of this studio. It is possible. But is it reasonably probable
that it can happen?
A human being can develop wings and fly out? No. So it is not possibilities that we are dealing with. It is reasonable foreseeability that this thing may result in fear and alarm.
Rationalization, logical conclusion.
You ask yourself, what is fear and alarm? What is fear and alarm? Now, on that basis, let me ask this question. If I say that the First Lady has received an amount of money from a controversial source, is that on reasonable probability likely to incite all of us that we should get on the streets and
demonstrate or do one thing or other
which is untoward and which is unlawful, or the second regime to disturb the public peace? If we are dealing with possibilities, then of course everything will ask us, it's possible that if you say something like that, we'll all get out on the street. But reasonable foreseeability.
Is it probable?
Is it reasonable, not just probable, is it reasonably probable that?
Reasonably probable, right.
A statement like that is going to result in that. If that is the case, and I'm not trying to prejudge the case, every statement we make, which is likely to go down as far as the public is concerned, could just propel us on to act right now. If I hear that something has happened out there, I could pick up my gun and then go out there to shoot everybody on sight. But is that really what the law is talking about? Is that really what the law is talking about?
You answer, is that what the law is talking about?
I doubt that.
Thank you. We have inserts of the Owusu Bempah arrest, and we want you to take a look at it, after which we'll take a break and we'll be back.
We have been told he's been sent, he's at the BNI here, and he's been charged for publishing false information and misdemeanor. which is baffling to me. I'm not a lawyer. I don't have the legal sense. But rationally, if I defame you, I believe it is for you and your legal team to decide whether you want to take me on or not. Not an issue. I can't go and report you to the BNI and tell the BNI to arrest you and charge you on my behalf. You don't do that. For defamation, this is I have defamed you, and for that matter, it is a civil matter. And why are they not telling us where Osu Bempa is? He was sitting with his lawyers. They picked him up and took him away without informing his lawyers. How do we run a country like this? If the BNI and the police and the CID, they are capable of running the affairs of this country, and they know their job very well, I entreat them to try hard. The 44 Ayariga Highway, the 44 Ayariga Highway, which is packed with corrupt streets, they should go and eradicate us of that highway. That 44 million that has been used in purchasing Atlas books, aside that 92 million that has been paid to CP, aside that 51 million that has been paid to Alfred Agbeshiweyemi, we want those monies, not the arrest of Osu Bempa, per the comment. I want to ask the president one question. Does he think this action will foster unity in his party? That's up to him.
We all belong to the same organization, which is Fonka and NDC as a whole. And we know the in and outs, and we know that our brother was informed. He was called and told that they want him to come to the BNI to answer certain questions, which as a citizen of this country and a law-abiding citizen, he honored favorably. He comes here only for him to be interrogated, and then later he says he's stepping down to wee-wee or take his to urinate, and then all that we know is he has been taken away. We don't know where he's been taken to or where we don't know. But are we living in a country where there is rule of law? That's where we begin to wonder. But what we are saying is that there is a particular person that this thing was directed to, and that is the former the first lady. The First Lady Nadu Mills. If she thinks that whatever has been said about her is not true, and she has anything to defend, she should go to the law of court and go and defend herself, and then call for Owusu Bempah's head. But why should they use state power to defend themselves because they are the first couples of this country? Is that what Mr. Rawlings trained Mr. Bills to be? No, we are in a democratic dispensation, and we want to say that they should use the court of law to make sure that they channel their grievances if they have anything whatsoever against Owusu Bempah. What Owusu Bempah said, we know for a fact that Owoyome's money, they and the people who claim they are in power now, they spent the biggest chunk of that money, and now they are putting it on Owoyome as if Owoyome.
Now the question is government using state apparatus to protect his own interests? Does the state have a right to act on behalf of the First Lady, given the circumstances that we saw?
In my view, looking at the law and knowing that the laws are clear, as I mentioned much earlier, you're looking at the police with power of arrest. Nobody decides for the police when to arrest or when not to arrest. We cannot sit here and possibly assume or second guess what actually went on behind the scenes.
No, but as a lawyer, do you think the police was right in taking the initiative? If indeed Mr. Hamza says, sorry about that, your rank is, you're not a mister, you're superintendent, chief superintendent Hamza. I apologize, yeah. Yeah, that's contempt, yeah. Oh dear, I'm in trouble. Yes. A hangable offense. A drinkable offense. Okay, I get away with it. Thank you. Right. Again, did the police have the right to do that?
The issue is, did the police have the right to arrest? I think let's put it this way.
To arrest Owusu Bempa? To
arrest anybody whom they suspect of having committed a crime. That is the issue. And my answer is yes, to the extent that they have been given the power to implement or enforce the law. Now, this issue is different from whether what they did was...
Can you state that question again? I put a question to you and you bounced it back and changed it. I asked you if the police have the right to have done the arrest, taking the initiative to arrest on behalf of the state for causing, well, what was said was fear and panic, but you have corrected it to be fear and alarm, right?
That is actually what the law says.
Did they have the right?
That is what the law says. And if you look at Article 23 of our Constitution, Article 23 is basically saying that administrative bodies and administrative officials have a duty to be fair and must act reasonably, and they must comply with the requirement imposed on them by law. Now, similarly also, if you look at Article 296, there we talk about discretion and exercise of discretion. Now, what I'm looking at here is the institution and what the law is saying. The law has, created an offense. Of course, if you want to question whether the offense is an offense, okay, then you are directed at Article 2, Section 208, which clearly creates the offense. Now, the issue is whether they do have the power to arrest any person they suspect of having committed an offense or not. Now, having effected an arrest, the law again says that you must produce the person before a court of competent jurisdiction within 48 hours. Now, in this story, what I do not see is the court aspect, okay? Now, if they...
So clearly the police had the right to go ahead and arrest him.
You can arrest, but the law says that produce the person or the body before the court. Now, you're talking about, of course, other comment about whether the whereabouts or not is not known. Again, in law, the lawyers have the right to go to court and apply for habeas corpus. I mean, all these mechanisms are there. We don't see that being,
That is demanding that the person charged with the offense be brought to court.
Precisely. If you don't know the whereabouts, these are things in our laws, okay? And we have the right to what? Operate them.
Mr. Jabin, do you agree that the police had the right to go ahead and, make the arrest of Owusu Bempah in this particular case?
My learned friend is saying, under our arrest regime, the police have very wide powers of arrest. They can arrest with or without warrant, okay? But it is for a purpose.
It is not about the warrant here. It's about somebody has published an offense, a statement about the first lady.
Yes.
And then the police decides that this statement or whatever amounts to defamation or character assassination or whatever else they perceived it to be, and therefore we will act on behalf of the state.
See, that is why he said earlier that they have wide powers of arrest. They can even arrest you on reasonable suspicion for doing something, but it is for a purpose, and that is why the Constitution requires that at the time of arrest you should be told the reason for which you are being arrested in a language you understand, for the person to know that this is why I am being arrested. Interestingly, we have it written black and white boldly in our Constitution, but we never apply it. You see, and the arrest is for a purpose.
You mean the police do not apply it, or we do not ask? A person who's arrested does not ask that his rights be read to him?
See, I don't want to go too far there.
No, but we do want to understand. These are the issues.
I doubt whether the police does that in this country, that upon arrest they tell you the reason for which you are being arrested.
I believe anybody who is being arrested knows why he's being arrested.
That is an assumption the police cannot make. So because you see, and for the purposes of argument, you find that in even when we watch movies, from the West, they say so and so you are being arrested, you have the right to remain silent, blah blah blah. Whatever.
As we are sitting in this studio right now, the police can come in and arrest me. Do I know the reason for which I'm being arrested? Maybe I must have said something.
They must tell you. They must tell you right away that, Mr. Jabing, this is for saying this and that, or for doing this and that, the police is under arrest. The
Constitution requires. They must read my Miranda rights to me, that this and that. But I was going on with
Chief Superintendent Hamza, does the police do that?
We do.
Consistently? Was it done? In the case of Owusu Bempah, was he told why he was being arrested?
Honestly, I cannot be sure about that.
Oh, it's not unfair, because I expect that he would have knowledge of this, because
I certainly was not. I was not privy to his arrest. And even though you are not in the legal department, you
would have adequate knowledge of how you act.
No, I know as a police officer that is the procedure. I know. Yes, I was not there, so I cannot tell you that. In any case, I believe he was invited to the police station.
But you are going to
what about the case of Amina?
Worms if you talk about invitation.
What about the case of Amina?
Before the court.
It's before the court.
It's still before the court.
So we cannot comment on it.
I think that this is where...
What about the case of Atidazi? Would you know?
No, I'm not aware about that matter.
Do you know a particular case, I mean, that we may not even know, that that the police made an arrest and said that A, B, and C?
I have personally been involved in the arrest of persons numerous occasions, and I always ensure that I comply with that.
I thought the officer was saying...
Of course, as if he was yeah, but you did say that. No, you did say that, and for me that is scary, to assume that a person would know why they're being arrested. And indeed, there are sometimes when false arrests have been made.
Yeah.
So if you make a false arrest and assume that, even in case of mistaken identity, what then happens?
You have the right to resort to any action that you think you can seek redress
But and then if I protest?
You protest.
Yeah, then while the arrest is being made.
You see, these are some of the issues that sometimes creates some sort of confusion when it is that we have to perform a duty. As a citizen, we expect that every citizen should be law-abiding. It is your own police. It is not a creation from any universe. Your own police that you pay to protect you has come to invite you to the police station, your own home, where you would necessarily go to seek protection when you are in trouble, and then you want to raise hell because you feel you
do you have the
don't
reputation with the public? Does the Ghana Police Service have that particular reputation with the public?
Come again with the question.
Does the police
Yes.
have that reputation with the public, that sense of confidence that this is my own police coming to ask me that come over and let's have a discussion, or you know, or that you've been arrested, and that you know that even after you've been arrested, no, it's not up to me. Even after you've been arrested, you can trust that the police will take care of you and do what they're supposed to do legally. Do you think we have that sense of confidence?
If you follow closely, these days, our mode of arrest these days, in most cases, we send invitations, and people comply.
You see, that's where I have
Yes, you have a problem with that,
I have a problem with invitation. The Constitution tells us exactly how, and Act 30 tells us exactly how we should carry out an arrest. If you come and invite me, I have no obligation to follow you. Are you my friend? You are invited by the station officer. To do what? If you are placing the person under arrest, place the person under arrest. But if you invite the person can refuse to go. Our jurisprudence on that is very clear.
How are we supposed to do it? How is it supposed to be done?
You place your hand on the person, excuse me,
okay,
and tell him.
You never know.
Yes. And tell him you are under arrest, and then you read his rights to him.
And what would that typically be, please?
Then he's under arrest.
In that case, he has
what
to submit.
would
Then
that typically be? Can you perform the function for us, for the sake of
place your
public
hand
education?
on the person and say you are under arrest for this and that and that and that, and that's you. Then your Miranda rights are read.
You tell them they have the right to remain silent.
You are not supposed to hold the person up and hook him up and
as
drag
we
him
normally
through
do.
the streets. That's undignified. Yes, but if then the police tell you under arrest and the reason for your arrest, then you cannot resist. If you resist, it's unlawful.
I think
shouldn't they show me? Should I not even demand for an ID of the police? Should I not demand, not the arrest warrant? Can I make a demand for the police?
It's not your personal opinion. It is what the law says.
Hang on a minute. Should the police not identify himself? Not just a warrant.
Oh, you can.
I mean, the fact that he is, yes.
You can ask him for his ID.
Shouldn't they flash the ID before they even?
I have on me my service identity card.
Sorry?
I have on me my identity card, even though I am in uniform.
Yes.
I have it on me. When I come to arrest you and you ask for it, I am obliged to let you have it, to see it, not to have it. I'll show it to you, signifying that, yes, I am indeed a certified police officer.
In practice, try asking the police that.
Show me your ID card. Thank you.
Well, I don't know, unless you have
in
examples.
practice, try asking the police that show me your ID card, but let's not divert.
You see, I was trying to chip in and say I disagree with lawyer. You are on the street in front of Joy FM. You are on your phone. Somebody approaches you at gunpoint or knife point. Madam, give me your phone or I'll kill you. You try to resist. You are slashed. The police arrives at the place. Then the police adopts this method of you are under arrest in the name of the state.
Of course.
No, I would hook you.
See, the person then is trying to resist arrest. There's a difference. If I said earlier
that is where you should have...
just a minute. I said if the person is being placed under arrest and the person is resisting, then the police have a recourse to resort to physical force. The person who stops someone in the street and is running away clearly is a fugitive from justice.
Yes, exactly.
Who really has to be brought
the
up.
person might not be even running away.
This is not a person that you, reasonably speaking, in practice, go and touch and say you are under arrest.
Somebody
you must ask
you
for.
be emboldened
You were
enough
talking
to stand there to await whatever.
I was talking specifically with the issue of
about a person in his house.
Yeah. Being invited.
If the person in his house has not, is not carrying out, what do you call it, a shootout or a standoff with the police, he's in his house peacefully. What prevents you from telling him that he's under arrest and you take him to the police station if he's not resistant?
According to the footage we saw, Mr. Usu Bempa got up to, go and relieve himself, and he was taken away. We cannot clearly say how he was taken away, but he was taken away and held for a period of time until he was released. Now, can let's say, can the president call and say that, call the police service, the IGPO, and say, you know what, I don't think that is right that, you know, you arrest Owusu Bempah, you detain him for longer than 24 hours or 48 hours, however long, so please let him go. Can he do that?
Indeed, the president, if it does that, has breached the constitution. Now, the executive authority of Ghana is extensive to the maintenance and enforcement of the constitution and all the laws. Now, the only instance where the president comes in is when a person has been convicted and he exercises the power of pardon. Okay. Now, in this whole story, I think people have different views, people have different emotions and passion. But if you look at the law strictly, I think we can be objective here. Everything we're saying in terms of the law is that, indeed, I highlighted several laws, even before coming. And then I realized that, look, there are several of them that if indeed the police want to charge, could charge. You know, abatement is available to them. Okay, even contempt of parliament is a criminal offense, all right? Contempt of court, all of these laws are there, all right? Now, what is happening here is that, for me, the only problem I had with the charge was the use of fear and panic, okay? So if I were asking...
Which does not exist? You say it's
no,
fear and
obviously we haven't seen the charge sheet. It is what the paper put out there. Yes. That is what we hear. Let's draw this. And the police have the right to charge. Now, like I said, the matter hasn't come before the court, so we don't know the argument of counsel. In other words, we don't know what his lawyers will say. But possibly if the matter had come before the court of competent jurisdiction, I believe all these things will come up. But the issue is, can the police indeed effect arrest because they suspect somebody has committed offense or is about to commit offense? Or, I mean, this reasonableness.
No, these were not the issues that suspect. They clearly said that he had published defamation.
Yeah, but of course that doesn't mean he's a convict. He's only a suspect. Okay, now, on the issue of the invitation.
We'll come back to this, and you have sent in some text messages, so I want to share with all of us. Boga Samuel Ufuria Santi says, I didn't think they should have done it for her. God help Ghana. Bogofuri. He didn't think that the police should have arrested Owusu Bempah on behalf of the First Lady. Nana Kwame Chumesiankra says, Nadia Nkreni Ena Air Koso Ghana. I mean, what at all is going on in Ghana, he says. Amovi Kobikan Nyako says, I didn't think the police should have been in the First Lady's shoes. I mean, he didn't think the police should have acted on behalf of the First Lady. And Amovi Kobikan Nyako says, again, I see nothing wrong with what Owusu Bempah did. What is so serious than the General Secretary of a party saying 17 thieves struggling for flag bearer? The day the frog dies will be its long, God save another Ghana. I apologize for that. It's not quite clear, but I don't know if it makes sense to you. Dear Mente Orugbano says, honestly, people are benefiting from the underdevelopment of the police force, using the law officers to meet personal interest in alarming in our contemporary society. No doubt it's a sign that someday the mighties will fall from Niger. Frederick Akobing Jesse says, well, as a nation, we do advocate for the proactiveness of our laws, our law enforcing agencies, so that if really the charge slapped on Owusu Bempah is right, then I think the police didn't do anything for the First Lady, but they were only being proactive. But the point is that I really think the police was right to have picked him up. Perhaps he could help them with some useful information about the Woyomi case, which is now a national affair. Interesting thought. Do you follow what he's trying to say?
Yeah.
Here it says that a national matter is being discussed nationally. You know, there's intent here. So then, if he knows that the First Lady received a certain amount of money from Woyomi, then let's speak to him who else he must know about, or what else he must know about this particular case.
Tantamount to detention for 4 days.
Well, you will answer that for us. Yeah, now that is where the question of invitation comes in, or the issue of invitation comes in, that the police has invited for inquiry. I said earlier. And therefore, then they would not be taken to the police cells, would they?
As I said earlier, invitation does not amount to an arrest.
Arrest, okay. Here the pair Christian Young says, AC, what I believe is that in Ghana we have lawbreakers making law for us. What about those notorious politicians who are energetically beating the war drums with their unmeasurably money-filled mouth? What did they do to the one who said if the MPP is not declared winners of the election 2012 Afghanistan? I think the law must be revisited to meander through every angle to affect everybody, regardless of who you are. And Abdullah Muhammad Awal says, the law is a necessary evil because the proponents of the law foresaw how irresponsible some individuals and press houses can be with their reportage. I believe the main argument should be how and when it is appropriate for the law to be applied in order not to create the impression that it's a mechanism to silence the press or haunt political opponents. And again, Abdullah Muhammad Awad repeats, my concern is how the police work with dispatch when it comes to politicians, but tend to look around with how it affects ordinary citizens. The fact remains that her husband, the president, does not make her a public officer. If this is not checked, one should be arrested for arguing with the son of the president. And again, Scotty Nathan says, rule of law is not working in Ghana. Again, he asks why. And Yakubu Habila says, there's nothing like the First Lady in our constitution. Did Mrs. Mills make any charge against Bempa? Why did she not sue Bempa herself at the court? If the police wants to be respected, it should insist on it. It should insist on its neutrality. The arrest of Bempa was absolutely needless. And Captain Nana Prempe says, is it true that the First Lady accepted a gift of sort? If it is, then why will Mr. Woyome decide to dash out all these monies to one person as a gift? This is enticing indeed. I don't know, what do you make of the various issues that have been raised? And you can pick on any of them and answer. But then you said you had a question you wanted to pose.
Yes, I wanted to direct a question to all of us, though. It arose from what my learned friend Roland said earlier about the impropriety of the president asking or requesting the police to let a suspect go. The issue is this, and the question flows. Article 88 reposes in the Attorney General, who has a discretion as to who to prosecute or let go. Question is, who appoints the Attorney General and to who does the Attorney General report to? Can the President then direct the Attorney General that we don't want to prosecute this matter, so they should let the person go? It's for all of us to think about. And
I pose it to you from a lawyer's perspective, does the President have the right to do that?
Then the question becomes, who does the Attorney General report to? Who is he representing? Isn't he a presidential appointee? Yes. So can the President tell him, instruct him? Weren't we told from the Yoko report on the Woyome saga that the President instructed the Attorney General to go and prosecute the matter in court when they realized that they had paid the money by mistake? He reports to the President. Why can't the President instruct him to withdraw a case? In law, we say you enter a nolle prosequi if the case is already going. If the case has not started, they could drop the charges.
So would that not, procedurally, would that not be right? Because I think the issue was about the President directing or instructing the police to drop the case. But if he has gone through
not the case of Owusu Bempah. I was asking a question.
No,
with regards to the executive powers, yes.
Generally, not Owusu Bempah.
Let's take a look at...
So if it is that the President goes through his legal, what do you call him? His legal advisor. And the legal advisor thinks that it is appropriate.
Not the institution, but his legal advisor being the Attorney General. Is that what you are referring to?
Legal advisor to the government. But again, on that issue, let me also pose it this way. Now, in this case, we are not told whether the matter has even come to the AG's attention yet. The matter is still within the remit of the police, and the police are doing their job. And the question is, can the President instruct the police to drop it? Now, you see...
The question again is, can Mrs. Mills instruct the police to drop it?
We are not told. You see, let's be careful.
I'm asking, can Mrs. Mills say that? I have heard in the news
to answer you directly, if the charge is well-founded under 208, the First Lady is really not a complainant. Under Section 208 of the Criminal Offences Act, you don't need a specific complainant, because it is saying that if you publish a statement, rumor, or report, or you reproduce same, which is likely to cause fear and alarm to the public or to disturb the public peace.
And that is where our concern lies mostly, because this is an issue that is very topical. It's a national issue. The issues at stake are very contentious. They are talking about huge sums of money that are supposedly been fraudulently obtained, and then somebody comes in with a gargantuan allegation, which is likely to incite people. And then we are looking at the
how would that have been? And the issue of probable and reasonable comes in.
We have to be proactive. It is not for you to hear, but it is for us as a duty
stated, which is likely to cause fear and alarm to the public or to disturb the public peace.
Sure.
See, I said earlier, and I hate to repeat myself, we are not talking about fanciful possibilities. Reasonable probability. How does a statement? See, I am not holding his brief, and I'm not his lawyer.
Yeah.
I'm just a law lecturer. I put it to you in the classroom. How on earth, I'm still trying to wrap my mind around it, how a statement that the First Lady was gifted a controversial amount of money, which has become a national topic, is likely to incite all of us to go to the street and overthrow the public. Seriously.
That our actions are dependent upon intelligence-led investigations. We just don't sit down and come out of the blue.
Okay, can you explain to us how this can actually lead to fear and panic?
We are not talking about fear and panic. Fear and panic. We are talking about the alarm, fear and alarm.
Okay.
And then
how?
Wait. To the public or to disturb the public peace.
Okay, so please explain to us how this can happen so we can have a better appreciation of the police action.
I said that this is a very topical issue. The issues are very broadly based. Look at the dimension it's taken. I'm sorry to be saying that it seems to be assuming political dimensions. All sort of lawyers, all sort of courts have been introduced into this thing.
Does that make it likely to cause fear and alarm?
Lawyer, please. Our intelligence network has actually adequately convinced us that if we do not act timeously, we are likely to have a bigger problem on our hands. We aren't going to sit down and wait until people get onto the streets because of one statement.
You know what this is reminding me of?
What would really drive people to get onto the streets?
It is not for us to say. We are saying that.
But you made a determination. The police determined that the possibility.
Our intelligence specifies that yes, it's likely. I'm not going to divulge what we know. That is the purposes of investigations. We are investigating. And at the appropriate time, after we have concluded our investigation, we will surely send the docket to the Attorney General's department and let them tell us we have a case or we don't have a case.
This is one case that Attorney General will lose.
Why?
Well, we are not.
Okay, please come in here, Mr. Atakese.
I think that you have been very quiet here in the context that, for me, I look at the law. Now, I know people are mandated to apply the law. They can be wrong or they can be right.
And it's subject to interpretation.
Precisely. Now, what we have before us here is a situation where the police institution has been triggered to effect an arrest. Now, the issue as we have it has different dimensions, obviously by many people who may not have, sufficient information to even argue their way out. But the courts are there. The matter may not have traveled to the court yet. And I believe a lot of these issues will be battled, in the court. Now, as to whether what they did, for me, my concern, and listening to my senior and what he's saying here, is as if to suggest that the police do not have that discretion. And the police may not exercise that discretion. Of course,
I didn't say that. I didn't say that. What I was saying was I'm trying to wrap my mind around how his actions is likely to cause fear and panic or to disturb the public peace. I'm not saying the police.
It's for them to prove. It's for them to prove.
I agree with you that the police have wide powers of arrest.
Sure.
As for the arrest part, I have not even spoken about it.
Sure.
I wasn't allowed to speak about it. I have not even spoken about it. I am talking about the charge you say you've preferred against him. See, if you are charging him with such an offense, we can also advise you that what you're going to do, we're not going to yield any benefits because
we haven't charged him for any offense anyway.
Okay, that is what I'm hearing now. That's what I'm hearing now. Clearly.
Okay, so what, you picked him up. So what did you do? You picked him up.
So
hang on, you picked him up. The police just picked him up.
And we are investigating, yes.
You just picked him up.
Yes.
So he was not arrested. Was it an invitation?
Hold on. An invitation turns into an arrest when the person is formally taken into custody. It turns into an arrest. Once we restrain your movement.
But you have not charged him. I don't understand. Perhaps I'm a layperson.
If they were clear in their minds as to whether they could charge him under 208, they would have charged him.
But would they not have? Didn't you say that once an arrest occurs, there should be a charge to follow?
Not necessarily.
I said that, but if you can't find a charge, you can't dream up a charge. By our laws, there must be a specifically written.
No, my point is, I'm trying to. I mean, in very lay terms, somebody has been invited. A person has been invited to come and have a discussion with the police officer. And then it turns into an arrest because they are detained. Then they're not charged. I don't understand this because
if you can't find a charge, let him go.
But should they not have charged him? Immediately they discovered that they were going to detain him, and that.
My hunch now is they are forum shopping looking for an offense to charge him with. That's my hunch. From a lecturer's point of view, I think they are going through the law looking for something to put.
It means specific law.
What did you pick him? What law did you pick him under?
He's not saying he's not being charged. On one score, he's been charged.
That's why I'm asking. Please, let's try and get some order here.
Let me come in here. Now, I think that the process for charging the suspect, in terms of our criminal procedure, the police may invite you or the police may conduct investigation. And in the course of investigation, they may not have charged you yet, but they would take statement. Now, when the police decides to charge, then they have to caution you. So the caution statement comes in. I haven't heard of issues of caution statement in this matter. I haven't heard of any, in fact, we've not even cited the caution statement or the charge sheet. All we know is what is in the media. Now, what Kisi said with respect to the shopping for offenses and other, I think that indeed can be worrying. And I think this is where others will have concern with the police. But for me, my view on this matter is this. I am looking at how prompt they brought the gentleman before the court of law, how they cooperated with their lawyers. I mean, these are human rights issues, which must be protected. Of course, were
they protected?
Well, we don't have sufficient facts on this matter, except what people are saying. Now, all of these are allegations. Honestly, we do not know what might have happened behind the scenes. All of these things are, rumors and gestures, which I think that as a professional, I would not take too much, consideration of that, because we're looking at the law. We're looking at strictly.
Was the law applied as it should have been?
If I feel you have not applied the law, I go to court.
No, I mean, in this particular instance, was the law applied as it should have been?
There is that presumption of regularity, which means that public
don't speak lawyer language here.
No, this is not lawyer language. I mean, the idea is that it is assumed that public bodies are acting right. Now, if you feel public bodies are not doing the right thing, then you have the right to seek redress in court.
As a lawyer?
Yeah.
The case under which under study.
Sure.
Was the law properly applied? Sequentially?
That's why I'm saying that
as it should have been.
I don't have sufficient fact. I haven't held any
based on the facts that based on the discussions that we've had. Yes.
Yeah, it is too general. The discussion as we have, the facts as we have are too general. It could sway in whichever way. And this is why we can sit here and postulate. One may take it from this angle, other from another angle. But if I were acting professional for him, I would have gone a step further, ask more, see what was done. Well, we told that the lawyers
apparently his lawyers were yes, exactly.
Good. Why didn't the lawyers go to court for habeas corpus?
They were in court.
They were in court yet waiting for him and he didn't show.
See,
well, but if they were in court, maybe they were in court because of the charge. But when the person was not brought, why didn't you initiate the process for habeas corpus?
Are you assuming that they have
no, is it a point? They were as a fact
that they were informed he was being taken to court?
I'm wondering. I'm wondering why a lawyer will go to a specific court sitting there if he's not been informed that it's clear. There are so many courts in Ghana here, criminal courts in Ghana here. I'm wondering why a lawyer will go to, for instance, if it's a circuit court
lawyers adequately know the procedure. That before we could have left for the court, the man ought to have been charged. We first obtain a conscience statement,
so his lawyers
listen to his story, conduct further investigations. When we are convinced or when we are prepared to go to court, then we charge him for court. All of these were not done. He had only given us a caution statement based upon which our further actions were to be determined. It was at that stage, maybe we realized that there was a need to grant him bail, which we did.
You see.
So the courts, the lawyers going ahead to the place. We heard in the press that nobody knew his whereabouts.
Granting bail.
Where did you get to know?
Granting bail. What does it mean? What does it mean to grant somebody bail?
To release the person.
Yes, I do understand when they've not been clearly charged. Of course, please forgive me. I'm very late. I don't know the law.
The offense in question is even a misdemeanor, which means under the law you cannot imprison for more than 3 years. All right.
But
now,
again, let me ask you: when you're granting bail, what does it mean?
The police, in the course of their investigation, may observe that even the offense for which you are being investigated or arrested is not made, so they can, one, discharge you, or they may give police inquiry bail in terms of when the matter is one that is within their remit. Okay, an offense like this is a misdemeanor, not a high crime, which will involve going to the AG. So they could also give, bail in this instance. Now, in all of this, the law says that if you do grant the person bail, then make sure that you don't exceed 48. Bring the person before the court for the court to either grant the person bail or not to grant the bail. You see, this is what the law says.
Mr. Kisejabing,
yes.
You had a position on this.
You see, let me take it one after the other. I've heard from my two gentlemen here that there must be a caution statement, there must be this statement, there must be that statement. The Constitution does not require that. A little bit of public education, we are all learning. The Constitution says a person who is charged can remain silent. Are you going to force him to produce a caution statement? Are you going to force him to produce something? If he says that he doesn't want to give a statement, you can't force him. But here we keep on doing it, we keep on doing it, we keep on doing it. A person is arrested, immediately he goes in there and says, put down your statement. A person says, I don't want to
But Mr. Jado, obviously the caution statement actually reads that you have the right to remain silent.
I was quiet. See, listen. The two of you were insisting that there should have been some statements before the matter was brought to court. And I'm challenging you that that is wrong. The thing is that the Constitution says that if you are charged, you have a right to remain silent. If the person has a right to remain silent, why are you saying that at all costs we must have some statements before we go to court?
Please. Before a statement is taken from a suspect, these caution words are administered. That you are being investigated for this, you have the right to a counsel of your choice, you have the right to remain silent. If you say, I am not going to say anything, that is the statement that we put down and then you sign. And we consider that as a statement.
Have you heard of that before?
It happens.
Someone actually said that he wasn't going to say something and they just allowed him to say that.
But that would also be an assumption. That is an assumption of what goes on. But we do not have proof.
This is my concern. This is my
concern. Okay, quickly, because we have to go.
Yeah, this is my concern. It was their insistence on there must be some statements before the court. That's what I'm saying that.
No, maybe you know what we don't know. I don't know.
Please, allow him because I do have to end the show. So please allow him.
Please, you can differ. Does not the Constitution say that a person has a right to remain silent? Can you force a statement out of a person?
We never do that.
Wherein lies your disagreement?
Now, even if you look at the caution statement.
Please.
Now, remember that, of course, the Constitution envisages the existence of other laws, regulations, including the police regulations and all that.
The police regulations cannot...
Has the libel law been tested in Ghana?
Which libel law?
Civil libel law.
Yeah,
has it yet been tested?
It's always. I mean,
no. When I say tested, has somebody actually taken on somebody and gone all the way to the courts and there's been ruling since it was repealed in 2001?
No. We're talking about criminal libel.
No, I am saying that since the criminal libel was taken off.
Yeah,
that's the difference.
Yes,
the civil libel aspect is still ongoing.
Is being processed.
Civil.
No, my question, let me ask my question again.
Criminal
has somebody, I'm not talking about criminal libel, I'm talking about civil. Somebody says to me that I have offended them by publishing, defamatory words.
Personal example, I have about 5 defamation cases sitting on my desk right now.
And they're suing them for defaming them.
Especially the print media.
So my question is, has one gone all the way to the court and judgment passed?
On a daily basis. On a daily basis, the civil aspect.
So it's actually, it can take effect, and it's possible that you could go to the court and sue somebody for defamation, and it will be.
And in this case,
then the police may not necessarily be needed all the time.
Please,
we have to go.
Yeah, I know, but let me clarify this point. I think I made this point earlier. Merely because the criminal prosecutions are ongoing doesn't mean that one cannot initiate a civil action.
Thank you very much.
Okay.
I'm sorry, unfortunately.
Prosecution on what? Libel? Is that what he's talking about?
More food for thought. Thank you very much, gentlemen. I do appreciate you coming here for us to attempt dealing with libel.